Welcome. In this breakout room, Kevin Dolan, partner at Mullen Coughlin LLC, which represents organizations facing data privacy events and information security incidents, will share regulatory and incident response trends. Kevin will share his perspective based on Mullen Coughlin's experience responding to and investigating more than 25,000 data privacy and security incidents. A graduate of Temple University's Beasley School of Law, Dolan has counseled a variety of organizations on each stage of post-incident response, including compliance with applicable laws and responses to investigations conducted by federal and state regulators. Thanks for joining us today, Kevin.
Thanks so much, everyone, for being with us here today. My name is Kevin Dolan, and I'm going to be taking you all through our presentation today, where I'm going to be focusing on some of the regulatory and incident response trends that we are seeing on the ground here day to day in our practice. And before I jump in, I'm going to give just a little bit of background on who we are, what our firm does, and why we're presenting on this topic. So, Mullen Coughlin, we are a data privacy and information security specific law firm. We're headquartered just outside of Philadelphia, and all we do, 100% of our practice is dedicated to helping our clients either prepare for or respond to data security events. So we've got over 120 attorneys, and each one of us, is really living and breathing this narrow niche area of the law day in and day out. And just for context, you really have kind of three different aspects of our practice. The first is our proactive advisory compliance group, where, prior to an incident, clients will oftentimes bring us in for, from an information security standpoint, thinking about what steps can you take before an incident to either avoid or mitigate the impact of one does occur, or just overall, how can we improve our overall privacy compliance posture. Then on the flip side of the coin, we also have our incident response practice, where following an event, which is really going to be the focus of a lot of our conversation today, following an event, we'll be hired to come in and really serve as that central cog of the incident response process, certainly coming in to provide legal advice, but really being with our clients from the beginning to the end following an incident, whether it be business email compromise, ransomware, third-party breach, and guiding them effectively through the incident response process. Then finally, we also have a regulatory response and class action defense team where, following an event, if it does result in regulatory scrutiny or class action litigation, we have a team of experienced litigators who help our clients through those events. So that's really the context for who we are and how I'm going to be presenting the information to you all today in the presentation. And really, before we dive into the full content of the presentation, I'm going to start here on this first slide with some of the more recent regulatory updates that have been enacted in this space, or at least are on the horizon, and represent the potential to have some significant impact on the obligations that may flow prior to or from a data security event. So as you can see here on this slide, before I really get into those regulatory updates, it's always helpful to make sure that everyone has a really solid grounding in the fundamentals. And in order to do that, I'm going to spend just a minute or two here with a look on this slide of, what is the overall approach at the state level to data privacy and information security laws that has come into focus in the recent years. So as you can see here on this slide, at this point in time, we have all 50 states that have passed data security laws that are going to require notification to affected individuals when there's unauthorized access to or acquisition of their personally identifiable information. And there is some level of variance amongst the states as far as the types of data elements that are being protected. However, across the board, and as a minimum, every state is going to pull in things like name plus social security number, driver's license number, financial account information under this umbrella of their definition of PII. So what makes it complex and what really is going to drive your obligations following an event is really going to come down to what are the types of data that were impacted and what are the states of residence of those impacted individuals. So we're talking a lot about individual notification obligations, but in addition to that sphere of requirements, more than half of these states, in addition to individual notifications, also have a regulatory notification requirement as well, oftentimes requiring notification to a state attorney general following an event, depending on whether or not specific thresholds have been met, consistent with numbers of affected individuals within those states. So again, we're going to see variance amongst these statutes, but regulatory notification is often something that would be required by these statutes as well. And rightly so, we've been talking about the variance that we see across the states and how they're defining PII. But we also do have some level of deviation from state to state with respect to when notice must be provided to affected individuals or regulators. Some will have specific timing requirements, some will have more generic without unreasonable delay. But again, it really underscores the importance of drilling down on the specific states of residence and specific statutes that are going to be implicated following an event so that we can understand what those obligations are going to look like. Then this last point here, you can see that we have varying approaches to requirements for attestations of compliance and or private rights of action amongst the states as well. So again, what is developed here is this kind of a patchwork of statutes that are applicable in this space. And again, what is really going to guide obligations flowing from these events is having that really firm understanding of what are those types of data elements that are impacted and what are those specific states of residence, so we can understand what specific statutes we need to be looking at. So what we have there is our 50 state survey in about 90 seconds. But again, it really does lay the groundwork for what we're going to cover on the next few slides, as we're going to delve into some of the developments that we've seen across the landscape in the last year or so. So, that begs the question, which we'll answer on this next slide here, is what have we seen as far as trends are concerned in the recent years? So, what we've seen, and as detailed in this slide here, we've definitely observed an uptick, in regulation and enforcement with, more states requiring that regulatory notification following an incident. And in turn, more state attorneys general launching some level of an inquiry requiring additional information following these notifications. And, as I alluded to on that last slide, we've also seen more and more of these states expanding the types of data elements that are now protected, right? So we talked about, what's generally considered the big three with social security numbers, driver's license numbers, financial account information. What we're seeing are states expanding beyond these traditional three data elements, the types of information that's going to be protected and considered personal information. Again, going beyond those standard elements and now looking to include things like biometric data, email address with passwords, health information, sometimes health insurance information, et cetera. So it's a growing list of what these regulators are looking to and what these legislatures are looking to as protected and potentially sensitive information following these events. Another development with really significant implications following an incident is the fact that many states have now also passed industry-specific laws that will extend protection, well beyond our traditional conceptions and understandings of PII. So, for example, we have a handful of states that have now enacted privacy laws that are going to protect broad swaths of, as an example, student data that are maintained by educational vendors, educational entities, or vendors, and really requiring varying levels of notification and action following an incident. So now, we're faced with, in addition to drilling down on, types of data elements and states of residence, but depending on the industry, ensuring that, we are identifying any potentially impacted or triggered industry-specific requirements that are coming into vogue. So again, these are all developments that are generally increasing the obligations on impacted organizations that would flow following a data security incident. But we do also have some positive trends for victim organizations in the opposite direction. So specifically on this last point here, you can see that we have a few states that have now begun to incorporate in really affirmative defenses to their statutes that can potentially provide some relief to impacted organizations if certain industry recognized standards are in place. And I'll get into a little bit more detail on some of those points when we talk about some of the proactive best practices we can consider and we can put into place prior to an event, which we'll cover a little bit later on in the presentation. But I'm going to jump to the next slide here, where I've got some detail around some of the regulatory developments that we've seen in specific states. So, in 2021, going back a couple of years, we had 5 states that amended their state data breach notification laws. So we had California, Connecticut, and Mississippi all expanding their definitions of personal information. We had Connecticut shorten its notification timeline. Then we had Texas and Washington amending their state attorney general notification requirements. And though, I don't have it on the slide here, 2021 also saw 4 states enact some of those industry sector specific data breach notification laws that I noted on that last slide. So specifically, California enacted some regulations under its state medical data breach notification law. We saw Indiana hand down new requirements on state educational institutions following a cybersecurity incident. We saw Illinois amend its Student Online Personal Protection Act. Then we also had New Jersey implement specific regulations around certain aspects of critical infrastructure. And you can see that trend carried right on through last year, where in 2022, we had another 3 states that amended their data breach notification laws, in large parts and in generalities to really implement stricter mandates. So in Arizona, Indiana, Maryland, we saw heightened strictures put in place around regulatory notification and timing and content requirements for individual notices. So, what this really underscores, and we have, other pending and enacted changes to other state data breach notification laws in 2023. What this really underscores is, this analysis is never something that we're done, right? This is a constant cycle of ensuring that following an event, we're identifying not only the, appropriate types of data and states of residence, but ensuring that, we're looking at the most up-to-date regulations that are in place, because this is a really dynamic and changing area of the law. And in order to ensure compliance with the controlling statutes, we need to make sure that we're looking, for these recent developments, as this is an ever-evolving area of regulation. So what we've been talking about here, for the most part is, data breach notification laws, trends and updates in this sector. What I'm going to do on this next slide is really look at, outside of information security, look at where states are mandating actions, beyond just what happens following unauthorized access to protected data. So again, the focus of those data security laws that we've been talking about is really on keeping that protected data safe from unauthorized access, and then ultimately imposing duties and obligations following instances where that does not occur. So that's largely what we've been talking about on the previous slides. But on the other hand, what we can see on this slide is we've also had a lot of movement over the past 2+ years as far as developments in data privacy legislation, where states are now taking a much more active role in mandating good governance of the data that is held by organizations, really giving individuals far greater control over how their data is processed or shared. So to put that development into context, at the beginning of 2021, so not that long ago, just 2+ years ago, we only had 1 state, California, that had a comprehensive general privacy law, and that's the CCPA. So the CCPA is a relatively complex regulatory framework, but generally speaking, what it does is it imposes obligations on businesses and their service providers around things like data governance and stewardship, but it also gives consumers some pretty specific rights related to their personal information, how it may be used and how they may opt out of certain uses of that data. So, California, as it often is, was the trailblazer in this regard. But then in 2021, we saw 2 more states, Colorado and Virginia, pass similar data privacy acts, which, while containing their own distinct nuances, generally follow the structure set forth by the CCPA, again, with some really important caveats there. But what we saw is, that movement has not stopped with just Colorado and Virginia, because back in 2022, we had 2 more states pass similar legislation, with Utah and Connecticut, each passing their own respective statutes, granting distinct rights to their residents with respect to data privacy and governance. And that's a trend that we anticipated and saw continuing moving forward, as more and more states have and will enact similar data privacy laws. We're up to 11 total now. And again, we even with those new statutes coming into vogue, we also anticipate that those with existing laws, such as California, will continue to amend and expand the reach of the protections that are afforded under these statutes. So towards that end, California, again, is leading the charge here, because in late 2020, we had a large-scale amendment to the CCPA that was voted into law, with the CPRA amended version of the CCPA taking effect on January 1st of 2023. So among other things, what we saw with this amendment is of the newly amended CCPA under the CPRA is the expansion of consumer rights in a various number of ways by granting them the authority to do things like learning, what information a business has collected about them, giving them the right to request the deletion of their personal information, giving them the right to stop businesses from selling their personal information, and really, as a general matter, giving them many tools to ultimately hold businesses accountable if they do not take reasonable steps to safeguard their personal information. So again, lots of moving pieces in this area of, the regulatory landscape, but the trend is pretty clear. And, what we saw through the course of 2023, again, is we are now up to 11 total states. What we anticipate for the rest of this year and, moving forward is a continued expansion of personal rights around data privacy through state level activity and legislation, really underscoring the need for, organizations across industries to understand from a regulatory framework standpoint, just as a really threshold matter, understanding with all of these various statutes out there, what is the entire framework of these regulations that are applicable to us as, based on the industry that we occupy, based on the types of data we are storing and ingesting, having that listing and understanding of here is the framework that's applicable to us. And then really understanding how are you currently postured against those regulations? Are there any gaps? Is there any daylight between your practices and what these regulations say you must be doing? And if there are, what are the steps that need to be taken to fill those gaps in and ensure that you are as compliant as possible? Because this is going to continue to be a really active space as far as regulatory scrutiny and inquiry moving ahead. So that's all with respect to comprehensive state data privacy laws. And again, the distinction there is, outside of and putting aside obligations flowing from a data security event, which is, the unauthorized access to or acquisition of information. What are those obligations that are affirmatively handed down on organizations based on the types of data they're collecting? What I'm going to do on this next slide is pivot back, to that real singular focus on data security, information security, and data security events. And in order to do that, as we pivot back to, more of a information security than data privacy perspective, I think it's helpful to have a grounding in, what we're seeing here at Mullen Coughlin day to day. And what I have here is, a listing of the different categories and types of data security events that we see most often. So, the first and most common form of event that we handle here is some form of a third-party malicious attack. And again, that can take many different forms, anything from hackers in your network to malware or ransomware being deployed in your environment by a phishing attack or otherwise, even physical theft of your hardware. Various types of these third-party malicious attacks will ultimately manifest in a data security event in which, potential obligations may be flowing. So that's the first and most common form of event. The second are those events that are going to originate with your own employees. And that can either be intentional, in the form of perhaps a rogue employee who steals or sells data that you hold, or even by things like simple human error, where maybe someone on your team mistakenly sends, an unprotected data file to the wrong recipient, or fails to follow your policies in a way that results in unauthorized access to sensitive data. And then what we also see is that, both of these categories can also hold true for all of your business partners, who may hold any of your sensitive or protected data. Because the reality of, the way that these state data breach notification laws are structured as a general matter, even if that malicious attack or that employee error takes place on their end, on the third party's end, if it's your data that's impacted, the ultimate responsibility for complying with notification obligations, disclosure requirements is still generally going to be yours. So that's a really difficult lesson that a lot of our clients learn in this space. You can have the most up-to-date, the highest tech, best investments in data security for your organization, but ultimately your positioning, your posture with respect to data security is really only as good as that of any third party that has access to your data or access to your systems, right? Because again, even if the event takes place on a third party system, if it is your data that's impacted, ultimately that responsibility is still going to rest with you for compliance with the controlling regulatory frameworks. And then this final category here that we have is one that we've seen increasingly in recent years, and that's with respect to supply chain incidents that are deployed really efficiently to one organization, but then ultimately ripple out and impact a multitude of organizations and industry. And there are many examples to draw from. There's the Move It incident, which is in the news currently, and having a significant impact on a number of downstream clients. And if you think back to a couple of years ago, the Kaseya matter was a similar incident, which ultimately, had one of these ripple out supply chain effects from a couple of years ago. So, this final category is one that I always focus on because it is a scary development. To be sure, because of how efficient these threat actor groups have gotten with this deployment, right? So now instead of having to infiltrate thousands of different organizations, these threat actor groups have figured out that they can effectively get more bang for their buck, if they just target the Movits or the Kaseyas of the world at the top of those supply chains and really wreak havoc downstream through that chain. So again, these types of attacks are, vulnerabilities and matters that we're seeing more and more day to day here at Mullen Coughlin, which we think makes it even more important for organizations to really get a better understanding, a firmer grasp on, where does your own particular supply chain exposure rest? And what are some steps that you can potentially take to mitigate against that harm? So really thinking critically about who are those third-party relationships that we have with our organization, and if they were impacted by an event, what would the downstream impact on us be from both an operational as well as a legal and regulatory standpoint? So again, some critical and intentional proactive thought in this regard. We've seen really pay dividends on the back end, kind of thinking through where do you fit in that supply chain exposure? What are some steps that you can take now ahead of time to mitigate or potentially avoid any of those downstream impacts? So again, all of this is kind of abstract generalities, what we're seeing day to day. On this next slide here, I'm going to try and translate some of what we just talked about into real data, and looking just at some of the types and numbers of matters that we're handling here at Mullen. So we've seen some fluidity, but overall been pretty steady over the past few years, seeing anywhere from 3,000 to 4,000 total matters come into our firm for assistance. Again, some fluidity from year to year, but generally that trend has been pretty consistent, trending a bit upward this year to date. And then on the next slide, I'm going to blow these numbers out a little bit and really have just a quick snapshot on within those numbers, what are the types of events that are making up those 3,000 to 4,000 matters that we're seeing per year. So over the past couple of years, the top three types of matters have held pretty steady, with ransomware, business email compromise, and third-party breach generally being 1, 2, and 3. But last year we saw a bit of a sea change where business email compromises began to represent our most frequent type of event over ransomware. So I think there are lots of theories on why ransomware has decreased slightly year to year. Whether that be the geopolitical situation currently, destabilization of certain threat actor groups last year, lots of theories, no confirmed, correlation between one and what we saw last year. But what I can say is, we do anticipate an uptick and kind of return to normal levels this year based on the current trends and the activity that we've seen year to date. So these are types of matters. On the next slide here, you can see a little bit of additional detail here as far as the types of sectors that we're seeing most often targeted amongst our clients. So generally speaking, it should not be a surprise. We're seeing professional services followed by manufacturing and distribution and healthcare really continue to be prime targets for threat actors. And again, it's not a coincidence because these groups, unfortunately, they're sophisticated. They're growing in sophistication, and they really understand and have a keen awareness of the operational impact that these events can have, combined with the fact that the companies within these industries are most likely to have treasure troves of sensitive data that are likely to be protected by statute, therefore more valuable if stolen. So we're seeing them really target those industries where where can we have the most operational impact, therefore heightening pressure and the potential that an victim organization may pay, and where do we have the most sensitive and protected data, such that if that data were stolen, it would be deemed very valuable to try to recapture or recover for a victim organization. So what I'm going to do on this next slide here is give just a breakdown, specific to ransomware, on how often we are seeing our clients pay, why they're paying, and how much they're paying. So overall, we've seen a pretty steady decline in percentages of our clients who end up pursuing payment, which certainly is a positive development. You can see on the slide, though, we're not necessarily seeing the same positive developments with respect to amounts of ransom demands and payments when they do occur. So I think it's helpful to think about when our clients do end up pursuing payment of a ransom following a ransomware event, why are they paying? And I think we can largely break it down into three different buckets. So from an operational standpoint, when you're hit with a ransomware event, when this encryption malware is deployed throughout your environment, in order to get back up and operational, you've usually got three options that you're looking at. First, in an ideal world, you've got viable backups that you can restore from. If not, however, you can look at the potential of maybe just completely rebuilding your environment from scratch, though that obviously is just not going to be a feasible option in the vast majority of cases. Then the third option, if you can't restore or rebuild data on your own, if you want to get operational again, sometimes some of our clients will consider paying the ransom as a business decision, as if that is the only viable way for them to get back up and operational, is to pay for that decryption key to essentially unlock their data and give them access back to their systems. So that operational impact is, the most frequent rationale for which our clients will end up pursuing payment. The second rationale is with respect to data suppression, right? So depending on the type of data that was exfiltrated by the threat actor, it may be so damaging from a business standpoint or from a client relations and from a broader PR and brand management standpoint, if that information were made public or posted on the dark web or sold somewhere down the line. If it does have that type of value, sometimes our clients will consider payment for a promise from the threat actor that that specific data set will be returned, will be deleted, and not further distributed, right? So a couple key points there: irrespective of whether or not you get that data back from the threat actor, that's not going to have any impact on your legal obligations, right? Just the very function of that data ending up in the hands of an unauthorized third party in and of itself will generally trigger legal obligations. So you're not paying for the ability to avoid notifications, you're paying for the potential to avoid that data being posted or sold down the line. Then the third bucket where we'll see our clients sometimes consider payment is for harassment avoidance, right? These threat actor groups, as I mentioned, have become very sophisticated. They understand the realities of what are the pressure points that exist following these events, what are the levers they can pull to heighten that pressure. So whether it be through outreach to employees, business partners, executives, sometimes even the media, these threat actor groups oftentimes will engage in some level of harassment campaigns which will sometimes incent clients to consider payment. So the really important piece here is that, when we talk to our clients about the potential for payment, we always make sure that they're going in eyes wide open, and that to be aware of what they're actually paying for, right? And what they're paying for in all of these instances, is the promise of a threat actor group that, if we pay you this exorbitant sum of money, you're going to live up to your end of the bargain, and you're going to deliver that encryption key, or you're going to delete that data and not sell it down the line. And understandably, a lot of our clients will have misgivings about this. So, how can we be sure that this is going to happen if we pay? And our answer is that you can't be sure, right? There are no guarantees. When we push the threat actor groups on these questions, say, hey, our client, is not comfortable considering payment because they're not sure that, they're actually going to get what they pay for. The response is generally along the lines of, look, we are well-known groups in this space. If word gets out that we are not living up to our end of the bargain, and we're not honoring our promises, nobody's going to do business with us moving ahead. And by and large, we do see that, tend to be the case. Do we have instances where some of our clients have, paid a ransom and have been burned because, maybe they don't get the encryption key that they pay for, or maybe they pay for that data suppression and 6 months down the line, it shows up on the dark web. We do have those instances, but they are exceptions, right? But the really important caveat here is not always, do we have a trustworthy, threat actor group that's holding you hostage here? Sometimes it can just be, are they good at their job, right? We've had instances where, maybe we'll pay for a decryption key and they deliver it, but maybe it's only partially successful because, they did not apply the application correctly. So it's a difficult position to be in for sure, and one that really incentivizes our clients to think through, how can we remove the potential for us even needing to consider payment? And that's one area where we have seen some positive developments. And what we're really seeing is that, the resilience efforts that our clients are taking before they have an incident, whether that be really intentional development of an incident response plan, or pressure testing that incident response plan by conducting a tabletop exercise, or thinking through some really intentional strategies with respect to how are we deploying and storing backup so we can get back up and running following an incident quickly. We're seeing these resilience efforts pay off. We're seeing things, like I said, like those improved backup practices and deployment of endpoint detection and really intentional policy and procedure development. We're seeing that pay off to an overall decline in the number of our clients that have pursued a ransom payment in the past few years. So what I'm going to do here as we begin to wrap up a little bit is just on the last couple slides, take a look at, from a best practices standpoint, following an incident and even before an incident, which I'll get into in a moment. What are some of the things that we have found to be especially useful in our experience for either avoiding or at the very least mitigating the impact of these events if and when they do occur? So on this first point, what we found is, the ability for any organization's incident response plan to ultimately execute on their discrete duties and obligations following an incident is really going to be directly tied to whether and how often and how well they've been trained on the organization's incident response plan. So that's why, taking the time, devoting resources to things like developing those incident response plans and conducting those tabletop exercises is so crucial, because, the general tenet, what we found is that, you really do not want to be in a situation where you're testing out your plan and your team's ability to execute on that plan for the first time in the midst of an incident, in the midst of a crisis. So thinking through some of that really intentional planning, making sure that we have that incident response plan, that incident response plan really ties with your specific legal and regulatory framework, and that your team is practiced on it and is able to execute, is a really critical function before and after an incident to, again, avoid or mitigate the impact of one moving ahead. Next point here is, a really practical one, but it has to do with sequencing. And, sequencing really matters in this context. So we want to make sure that, following an incident, that you get external counsel in there first to ensure that all appropriate steps are being taken to preserve future claims of privilege around the investigation and its results. And then also to make sure that on the back end, you're aware of all of the various and complex laws that, we just spent the last 30 minutes or so talking about, making sure that we understand what they are and that we're taking adequate measure to comply with each of them. So making sure that you get counsel in immediately is the first order of business following an incident, and making sure that all decision points and all additional vendors are really flowing from that external counsel relationship, so that you're really protecting privilege and preserving your ability to assert privilege over the investigation down the line. We also always will work with our clients to make sure that appropriate coordination with, your insurance broker, insurance carriers, occurring to ensure that, all pertinent policies are activated, and make sure that you're submitting timely and accurate notice to your carrier as needed. So again, when we come in, we are acting as your counsel, you're our client, but to the extent you have a cyber insurance policy, making sure that your carrier and your broker have the appropriate information, so you're not running into any issues down the line, can be a really valuable thing to think about in ensuring that those types of procedural and housekeeping items are contemplated in your incident response plan. It's a really important feature. Then, from a messaging standpoint, following these events, I think the lesson that has been learned by a lot of our clients is that the language really matters here, right? So we have certain terms which have entered kind of the broader lexicon, like breach and PII, and people use those terms freely, but they do have, real legal significance and real legal implications. So you want to be careful about when and how you're using specific language in your post-incident communications, because if you start throwing around the word breach before you have confirmation on the types of information that were impacted, people are going to assume and imply that you've had, unauthorized access to or acquisition of protected data, when you may not be in a point where your forensics investigation has made such a conclusion. Another point with respect to communications is, we always want to make sure that you're not getting in front of the facts following these events. So there's always going to be pressure to be fast with your communications. There's always going to be a balance to make sure you're being transparent and communicative, but that's also always going to have to be balanced against making sure that you're not getting out in front of the facts. What we found through experience with our clients is, like, it is better to be right than to be fast in these situations. And it's really important to make sure that you're prepared for and have the answers for the questions that we can anticipate before you get out there with the messaging. Oftentimes, these events can functionally turn into issues of credibility, right? And fewer things can, further erode your credibility than going out with messaging early on following an event that has to be walked back either in part or in whole because the messaging doesn't align with the facts that are ultimately confirmed by your investigation. And then finally, again, you want to think about, in the context of these events, what are your applicable notification deadlines going to be under statute and law? So again, we've obviously spent a lot of time talking about duties arising out of statutes here, but what can oftentimes be overlooked is the fact that we could have notice obligations also flowing from contractual relationships that are entered into with third parties. And a lot of times what we've seen is, those contractual obligations can be a lot more aggressive than what is imposed by state law on both the timing requirements, but also the thresholds of events that are going to require notice. So I think thinking through really intentionally outside of just the potentially applicable statutory frameworks, it's getting an understanding and get our arms around from a contractual standpoint, what are some of those other obligations and other sources of, the duties and requirements that may be flowing from these events. So I'm going to do in the last minute or two here is just wrap it, not necessarily covered on the slide, but just some thoughts around, some additional administrative and legal best practices for consideration. And the first point that I'll emphasize here is around, again, the importance of really understanding your data from an organizational standpoint. And I say that because, what we found is that, ironically, it can be a relatively rare thing for our clients to truly have their arms around the full scope of data that's being held by and maintained by that organization. How long is it being held and for what purpose? Where's that data located and how's it being protected? But again, that awareness can really be key in mitigating organizational risk, and also can be a really beneficial tool in assisting in the response efforts following an incident. this concept around employee training is also a really crucial one. So really for two different reasons, right? On the substantive level, obviously engaging in this employee training is going to make your organization stronger, going to make your employees better equipped to spot and avoid these, potential phishing attempts, as an example. So it's going to make you stronger and less likely to succumb to an event. But it's also going to show that, in the event that an incident does occur, you can point to all of these great things you're doing with policy development, employee training, et cetera. You're going to be able to point at that this event occurred in spite of what you were doing, not because of what you were not doing. So again, if you got robust policies and training mechanisms in place, it can be really helpful on both of those tracks. And then, the last point that I'm going to end with here today is with respect to your service provider selection, going back to a point that was raised earlier, but I'm going to emphasize it here and reiterate it because it is a really crucial one. So again, that security that you are employing for your organization is only going to be as good as the security of your vendors or third parties that have access to your data. So when you're engaging in those relationships, when you're thinking about, who are those third parties that we are going to contract with, that we're going to give access to our systems, to whom we're going to share our data with, when you're selecting those vendors and those business partners that are going to have access to your data and your systems, it's really crucial to ensure that you're engaging in really robust due diligence to understand, what is their current posture with respect to security and compliance, and also ensuring that the contractual agreements that you're entering into with those third parties are adequately protecting your interests and shifting that risk where appropriate with respect to data security and privacy. So I'm going to jump to the final slide here, where we've actually covered all of the substance that we had on deck. Again, this is a complex area, an ever-growing area of regulatory and overall risk with respect to the threat landscape. We tried to pack in a lot as far as the types of developments and trends that we're seeing day to day. Obviously unable to unpack all of the nuance in this space in a short period of time. But what I'm hopeful is that, this broad overview and survey of the current threat and risk landscape and regulatory trends with respect to data security and privacy has been beneficial for everybody today. My contact information is on the screen here. If there are any questions about the content of what we covered here today, about our firm, or any specific issues relative to your organization, that might be helpful to discuss, please feel free to reach out at any time. But it was an absolute pleasure to have the time with everybody here today. And thanks for making me part of your day and working through the presentation.
Thank you, Kevin, for helping us understand the risks of not meeting compliance requirements from a business perspective. Please email us questions that you may have on how CyberSheath can help you meet regulatory compliance.